The request for next friend. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover the request for next friend, a SCAO form, State Court Administrative Office Form MC 319. Now you may ask, what is a next friend? It can get confusing because people often think of friend of the court. In this particular case, next friend is a fiduciary role in which a lawsuit is being filed by a person who is a minor or incompetent person, or the lawsuit is filed against the minor or incompetent person. A next friend can be utilized in the event that there is no conservator in place to represent that individual. So if there is a conservator, then generally there is no need for this process because the conservator would be the plaintiff in the lawsuit or the defendant in the cause of action. MCR 2.201E, one of the court rules, is reflected by the yellow arrow on this particular form, and the court rule MCR 3.703F applies in that case for personal protection actions. So if there is a minor or incompetent person and they're going to be a plaintiff in a cause of action, or they become incompetent during the cause of action, and there is no conservator in place, then the court shall appoint a competent and responsible person to appear as next friend. Again, a particular legal status on his or her behalf. And this form is the process to make the request of the court under the Court Rule 2.201E to request the next friend. And the next friend is responsible for the cost of the action. So again, plaintiff or defendant, there's a basis for the use of the request for next friend process. Let's work our way through this particular form. The form at the top left corner in the blue rectangle identifies the county court. In the red rectangle, simply it's the name of the form, and on the right side is the case number or petition number in the event that this is a personal protection action that is commenced by the filing of a petition. So you'd write the case number there, generally the case number upon which the circuit court matter is proceeding, or again, if it's under the court rule MCR 3.703F, it would be the personal protection petition number, which would be identified at that top section. So one of the biggest questions that gets asked is somebody is injured, for example, a minor, and they're injured in, let's say, an automobile accident, and the lawyer may be deciding, should we file that lawsuit with a next friend, or should we be filing that lawsuit after the appointment of a conservator? So generally, the shortest, easiest path is to simply request a next friend. It's typically done without a court hearing. There's typically no probate court involvement in relation to the appointment of that conservator, and the requirement to do an inventory and annual accountings and then ultimately end that conservatorship is not required in a next friend process. However, there are times that a conservator would be appropriate, and that could be when you have two parties, let's say mom and dad, who may be squabbling over who should control the litigation, and you want the court to make a determination that one person has the authority to make the decisions on behalf of the minor, and there's a need for a conservator. In addition, if you know that money is coming, meaning it's just a question about how much money is coming, but money is coming down the road, then it may just be a simpler process to obtain the conservatorship right off the bat. Because in the event that the minor is going to receive a sum in excess of $5,000 in any calendar year, it is mandated that a conservatorship occur unless, of course, you're going to annuitize the settlement thereafter. So again, a strategic decision that we are always happy to discuss with you about whether to appoint a next friend or to start off with a conservatorship. There's another court rule that we haven't yet identified, which is MCR 2.420. And that particular court rule addresses settlements in the event that there's a resolution of a case that involves either a conservator or next friend. There's a process upon which you have to follow under the court rule to get court authority and permission to pass on the sufficiency of the bond as well as the settlement. I also identified a statute, which is the statute that speaks of the amount of money that a minor can receive in any calendar year. Look up MCL 700.5102. Again, lots of statutes, lots of court rules that are involved here. And of course, maybe the easiest thing to do is to contact a lawyer like us that can guide you through this process. Let's work our way through the form. As you come off and you look at the top section, again, petitioner or plaintiff's information, defendant or defendant's information, with, of course, the relevant attorneys that are involved in the case. And in the matter of would be, again, under the personal protection piece, if you're asking through an independent action to be commenced by filing a petition. Otherwise, if it's a circuit court matter, it would be reflected above with a plaintiff and defendant. Now, here's the body of it. It's a request for a next friend. A next friend is necessary for, and then the person's name is identified, because he or she is a minor or incompetent or legally incapacitated individual. 2, the proposed next friend is, so you're identifying who you're asking the court to appoint. They have to be an adult and they cannot be disqualified by statute. And then, of course, there's a signature line. Below it is the consent. You can ask for the consent for the person above. If the person is 14 years of age or older, the person's next of kin or other relative or friend must sign the request. So again, we've seen situations where people bypass that requirement, and it is a mandatory piece of the request for next friend as it relates to the age piece. So please pay particular attention to the notes section that's reflected in the request for the appointment of a next friend. And then the lower section is the court order piece. Again, it's an approved form, so these are already pre-filled. It identifies that the person is appointed next friend for the person listed in item 1, or the request is denied because the next friend is unsuitable, and then a place for the judge to sign. Again, it's a pre-approved form. We also have seen these hand-drafted and written out rather than using the form, but we always think that we know that there's the use of these forms are really helpful because the courts are quite familiar with them, and you should really use the state court approved form when you can. It simplifies the problem and avoids the court rejecting the language that you may have written in your long drawn out request for next friend. So again, after the next friend is appointed, then I would refer to the court rule MCR 2.201 subsection E that identifies that you name the person as next friend in the cause of action, or if your cause of action is already pending, there'd be a substitution of parties to correctly identify that there's a next friend that is making decisions, serving in a fiduciary capacity for the minor or incompetent person. Again, as you get closer to settlement, be acutely aware of MCR 2.420 as it relates to the authority of a next friend to settle a case or enter a judgment. If you have questions about this form, as well as any of the issues involving a guardian, conservator, next friend, or otherwise, we'd be happy to discuss this matter with you. At the Probate Pro, we are passionate about everything probate. If you have questions about the request for next friend, call your friend at the Probate Pro, 833-PROBATE, or visit us at theprobatepro.com.